Good morning, everyone. Today we're going to be discussing the coverage WACEO has prepared for the Aragon Court. Aragon Court is a DAO which has a controversial but fascinating function, namely adjudicating disputes between other DAOs. Specifically, it functions as an arbiter composed from jurors and positions itself as the first judicial body with digital jurisdiction. The aim of the Aragon Court is to operate as a decentralized adjudicative platform which can be accessible to every individual all over the world, regardless of the applicable jurisdiction. There are real human jurors which are appointed in the Aragon Court, and every candidate has to have at least 10,000 tokens activated on their accounts. Even though the actual case is solved by the living people, the decision's execution is still based on smart contracts. This function of Aragon Court creates justifiable concerns with regard to the right of fair trial embedded in Article 60 ECHR, the contract law rules of Rome 1 regulation, and rules of market in crypto assets regulation proposal. Let's start from the right of fair trial. The question occurs as to whether the Aragon Court has the right to decide upon any case at stake in the first place. With regard to Article 60 ECHR on the right of fair trial, we have the following questions. A tribunal should be a court of law which is integrated within the judicial machinery of a state at stake. In the case of Aragon Court, this basic requirement is clearly not satisfied, as it is not established under any state jurisdiction, but claims to have a digital jurisdiction, which, however, is not accepted on the international arena. Thus, it can be seen as agreements concluded under arbitration or mediation, rather than actual judicial decisions issued by a competent judicial authority. It is also questionable whether the parties to the case at stake will be able to successfully appeal it in front of the real tribunal, especially taking into account the pseudonymity issues and jurisdiction conflicts, which are usually present in these cases. However, it should be noted that Aragon Court states that it is not an alternative to the judicial legal systems, which does not preclude the parties to also bring the claim to the actual real human-based tribunal. There are also several issues with regards to jurors' qualification. Article 60 ECHR specifies that judges must be selected on the basis of merit. Court members must fulfill the requirements of technical competence and moral integrity, allowing them to perform the judicial functions. Aragon Court, however, does not satisfy this requirement. Indeed, it is randomly selecting the jurors, and the selection does not take into account the background and the education and other issues which can be considered to the merit of the person who will be adjudicating the dispute at stake. Now let's move to the contract law issues. So if terms of an agreement concluded with the Aragon Court and the parties are clearly embedded in the code of the specific agreement of the smart contract, then the smart contract at issue can be seen as a direct manifestation of a conventional contract between these parties. This, therefore, makes the rules of contract law applicable to all agreements under Aragon Court. There are practically no rules governing which terms such agreements under Aragon Court can entail. Therefore, parties to Aragon Court proceedings risk drafting an agreement that will be in the future seen as void under the actual laws of a state where this agreement will be sought to be executed. This further creates uncertainties around the adjudicative mechanism at stake in the Aragon Court. The issue of pseudonymity of the parties can create even more issues with regard to the Rome 1 regulation. General contract law, as we already seen, is applicable to Aragon Court agreements with the parties to the proceeding. Therefore, the Rome 1 regulation is also applicable to them. Contracting parties are free to choose the jurisdiction in which the contract at stake can be enforced. However, if the parties do not do so, the principle of the closest connection comes into play. The third point to be discussed is the market in crypto assets regulation, which is still now in the form of a proposal. Nevertheless, it is interesting to see how this document, if of course adopted, will be applicable to the Aragon Court. The basic rules are laid down in the Article 4 of the regulation. To be able to offer crypto assets to the public on the European Union territory, Aragon Court must first of all comply with the following points. It should first be a legal entity, which it currently is. It has to draft a white paper, which it did. It must notify the competent authorities at the home member state 20 working days before the publication of the crypto asset white paper. Here, Aragon Court would have to register its branch in the European Union and to notify the country it registered right after the regulation comes into force. Nonetheless, it is questionable how exactly the registration procedure would be done in case of DAO such as Aragon Court. The white paper must be also published, which is already the case with Aragon Court. Lastly, Aragon Court would also have to comply with the requirements of Article 13 of the regulation proposal, which are concerned with so-called good faith. The applicable law to all of these issues will be the one of the European Union and its member states. And the Aragon Court is adjudicating cases on this territory. When joining a DAO, the member should not only be aware of the technical but also legal and regulatory risks. It is important that DAOs organize to develop and implement compliance roadmaps to achieve sustainable growth in line with the legal and regulatory frameworks. WACEO is establishing a non-profit association to build a trusted environment where compliance-seeking DAOs can interact with competent service providers to support them with novel legal and regulatory challenges that DAOs face. These little audits will provide a basis for DAOs to begin to clarify the risks that they face and work as a community to solve them. Thank you very much for your attention.